Hello and welcome back to this morning segment on Untangling the Gambling Act review. I'm joined in the studio by Melanie Ellis, partner at Northridge Law. How are you doing, Melanie?
Very well, thank you. Thank you for having me here today.
It's great to have you. Do you like our studio?
It's really good. Quite bright lights. I'm in the headlights here, but
it's good to wake you up first thing in the morning.
Yeah, definitely.
And how's ICE going for you so far? It's day 2?
Yeah. It's really good. It's really busy this year, isn't it? But yeah, good to be here and yeah, catch up with everyone.
So perhaps due to multiple delays, there's a great deal of anticipation for the white paper review. And do you think that maybe the industry is overestimating its importance?
I don't think they are overestimating the importance. I think we need to bear in mind that this isn't going to be the final word in Gambling Act reform, but it's a really important first step towards actually getting the regulatory certainty that operators need. So I think there will be a consultation process that follows the publication of the white paper, debate about potentially some legislation if that's needed, and very likely consultation exercises for the Gambling Commission to implement some of the changes in the LCCP. But we really need the white paper in order to now move forward with those changes.
And it's said to include 2 layers of affordability checks. So you've got an automatic background check followed up by more stringent checks at a higher level of spend. How workable do you believe this system will be?
Yeah, I think that is the correct approach, and that's the approach that a lot of operators are really following now, so that the checks that they're doing are proportionate to the level of risk. The recent language from DCMS is a bit of a change of approach from the Gambling Commission's affordability check language, now talking about financial risks. So it will be very interesting to see how that actually filters through to the requirements. But in my view, the intrusive level of checks should really be reserved for those cases where there is a reason to think that somebody may have a problem with their gambling, rather than it being used as a way to establish whether somebody has a problem with their gambling. So in terms of whether they're frictionless, I mean, I hate to bring up data protection law, but I think that's something operators will need to consider, and the Gambling Commission will need to consider, because if somebody is doing a background check, you need to think about does the player need to consent to that, which if they're having to tick a box to consent to a check, that may well put them off continuing with that operator. For the most part, people don't need to consent to a background check if there's a lawful basis for it, or the operator has a legitimate interest in doing the check. But there are rules in data protection legislation which say that if somebody is having an important decision made about them on the basis of a fully automatic process using their data, then they would need to consent to that, unless there was a lawful reason for that. So it's set out in legislation that check needs to take place. So that's one point that we will need to look into to see how frictionless these automatic background checks are.
And a number of provisions of the Gambling Act review will deal with data issues, from using affordability checks, as you were just saying, to assess problem gambling risks, to new powers that may be given to commissioners to analyse for non-compliance. What are the legal and regulatory risks of increased data sharing, and do you think that's likely to put off punters?
Yeah, so people would be right to be concerned about data sharing and data breaches that might arise from that. But it would need to follow the normal data protection rules again. So any data sharing needs to be proportionate to the reason for it being shared, and that usually means that the amount of data shared is the minimum necessary. So I think when it comes to operators sharing player data with the Gambling Commission, perhaps that's going to be more even on a sort of live basis for monitoring play potentially. It's very likely that could be anonymised, and it should be anonymised if that's still going to serve the purpose. So probably data breaches aren't so much of a concern as people might think they are.
And the Gambling Commission has been criticised in the past for funneling RET funds into dubious projects. How would the money that a statutory levy would raise be used?
Yeah, it's not really for me to say how the money should be used. I think first it's important to clarify that at the moment there are two different sources of RET funding. So there's the voluntary contributions operators make every year as a percentage of their GGY. And then there are the regulatory settlements that operators will enter into with the Gambling Commission in lieu of a fine. So in both cases, the Gambling Commission does have a role in deciding where the money's going to go. So it has a list of approved RET organisations, which is quite a mix from charities, educational institutions, and even some private companies on the list. And then when it comes to the voluntary settlements, the Gambling Commission approves where the money's going to go. It's just a panel of 4 senior individuals at the Gambling Commission who make those decisions, who don't, as far as I know, have any particular qualification to decide what is a valuable research project or to assess whether the money's really had the impact it needs to. And certainly the Commission has been criticised. So in the DCMS committee questioning in relation to the lottery funding, Andrew Rhodes was criticised for the fact that there wasn't really anything to show that the money had made a difference in the way that it was used. So if we're going to move to a statutory levy, I think it's important that there is that transparency and accountability as to where the money's going and is it really making a difference. Potentially it would be better for perhaps the government department to be making those decisions rather than the Gambling Commission.
And there's talk that one result of the review will be an ombudsman scheme to resolve customer complaints. What can we learn from other jurisdictions who have implemented similar schemes, such as Australia?
Yeah, so that's one of the things that the Gambling Act review was looking at as part of the call for evidence. It asked for information about how these schemes are working in other jurisdictions and in other sectors in the UK. I don't think there's really a model elsewhere in the world for what we would be likely to have in place. Perhaps France is an example where the regulator itself adjudicates on customer complaints. One issue that they have is that more than half of the complaints they have to reject because the customer hasn't gone through the operator's own complaints process already, so that's probably something to bear in mind. Potentially more informative are other sectors in the UK with ombudsman schemes. We've got quite a large number from financial services, legal services, energy, even we have a furniture regulator, it turns out. So some of these are established by legislation, some are more of an industry thing. So I think probably we'd be similar to perhaps the financial services ombudsman in that it would be established by legislation exactly how it's going to operate. I think one critical question for that is it going to adjudicate on customer complaints which relate to safer gambling measures? So quite often a customer might say, well, the gambling operator should have realised that my excessive gambling was caused by a gambling addiction, for example, and they ought to return my money. That's not something that IBAS or other ADR schemes can adjudicate on. And that complaint, when put to the Gambling Commission, can only inform the Gambling Commission's own review of the operator, so it wouldn't lead to any sort of result for the customer. So that's, I think if the Ombudsman scheme could somehow deal fairly with that type of complaint, that would be very helpful.
And Ireland's gambling regulation bill included broad language that could see banned any inducement to gamble. How should the government handle the question of bonuses, free bets and VIP schemes?
Yeah, I think we need to be very careful about any restrictions on bonuses and inducements in general. The Irish gambling bill is very widely drafted. And my concern is that a lot of promotional schemes could perhaps inadvertently fall into that. It may be that as that goes through their Parliament, the language is refined. The key concern is, of course, that if customers can't receive bonuses and free bets from regulated operators in this country, then they will fairly easily find those advertised by unlicensed operators. So I think if we were to have any language similar to the Irish gambling bill in any revisions to the law, it would need to be accompanied by some fairly strict IP payment blocking measures to prevent customers just finding their way to the black market.
Brilliant. Thank you for your insights, Melanie. It's really interesting to see where this is going to go. Thank you for your time.
No problem. Thank you for having me.
So up next in the studio, we go to the Gambling Commission itself and we speak to Andrew Rhodes, the CEO of the Gambling Commission. Stay tuned.